Morning, ladies and gentlemen. Thanks for coming. I'm Siobhan Gates from the news magazine Profil, and I'm very happy to introduce a round of experts for a quick talk. Astrid Reisinger Coracini is a lecturer at University of Vienna and an expert in international criminal law. Manfred Nowak is a human rights expert and and a special UN rapporteur on torture. Some time ago, but it's still important. Wolfgang Benedek is also an expert on international law at the University of Graz. As we have very little time, I do want to start right away. We're going to each have a quick 5-minute introduction in their fields of expertise. Let's start with you, Professor Benedek. You've chaired the first fact-finding mission under the Moscow mechanism into Ukraine. Can you tell us something about your work in the field, about the challenges you met there?
Thank you very much. Ambassadors, Excellencies, ladies and gentlemen, it's my pleasure to be able to make a short contribution on this very important historic day. My first remarks will be on the importance of fact-finding to clarify allegations of violations. The war in Ukraine is also a hybrid war. There is massive disinformation, spreading of fake news, war propaganda. So there is a need to establish the facts, where possible the truth, in order to provide justice. International fact-finding missions can contribute to clarify such allegations. I would like to give you the example of the Moscow mechanism of OSCE, created in 1991, which allows to establish a mission of experts to investigate issues related to the human dimension of OSCE commitments on the request of participating states. In this case, Ukraine, supported by 45 OSCE participating states. Such expert missions can be quickly established and reports presented to the OSCE Permanent Council to be immediately made public after being discussed there. So consequently, the report of my mission, consisting of 3 experts, was the first international report when presented in mid-April, right after the crimes in Bucha became known. Its wide mandate covered allegations of violations of international humanitarian law, human rights, and crimes against humanity. In our work, we benefited from the cooperation with the 5 AM coalition of Ukrainian NGOs. 5 AM will tell you something. That was exactly the moment when the war started. They are documenting war crimes as well as other international NGOs like Human Rights Watch, Amnesty International, and very importantly, the help of investigative NGOs like Truth Hounds or Bellingcat, specialized in open source investigations, and also to mention the UN Monitoring Mission on Human Rights in Ukraine, active there since 2014. Bellingcat, for example, was able to establish exactly how the downing of the Malaysian airplane happened there against all Russian disinformation at the time. While not all allegations could be investigated by our report, we found a clear pattern of violations of international humanitarian law and of human rights, particularly the latter in the occupied areas, partly amounting to crimes against humanity related to extensive and systematic attacks against the civilian population. The basic principles of international humanitarian law of distinction, proportionality, and precaution were all violated. Our findings were confirmed in more detail by a follow-up mission under the Moscow mechanism and by the independent international mission of inquiry established by the Human Rights Council of United Nations based in Vienna, as well as other mechanisms. For example, while Russia claimed that the maternal clinic in Mariupol was empty and used by Ukrainian military and therefore a legitimate target of attack, we found that this was totally untrue as was the Russian allegations that the Azov battalion had blown up the academic theater in Mariupol, which hosted several hundred women and children and was clearly marked on both sides with the inscription "Kids on the ground." Also, the Russian claim that generally no civilian targets were attacked could be proven wrong, taking, for example, the large number of healthcare facilities attacked, which we were able to identify with the help of the humanitarian lab of Yale School of Health, analyzing satellite imagery, the same institution which recently published a report on the forced relocation of thousands of Ukrainian children to Russia. In the meantime, the large-scale attacks on critical civilian infrastructure proves the real intentions of Russia. A major challenge is the proper documentation of by now more than 70,000 registered cases of presumed war crimes and the coordination of the various state and civil society actors involved in order to bring them to justice and thus prevent impunity. The supportive role of Eurojust to be extended is to be welcomed in that context. One example of good practice is the International Accountability Platform for Belarus for the documentation of war crimes, organized by Dignity Denmark together with Redress UK and a group of local NGOs led by Vyasna, which was initiated in response to one of my recommendations in my report on Belarus in 2020. Their expertise is now shared with Ukrainian NGOs. So this issue of accountability is all important, and I hand over to the next speaker. Thank you.
Thank you. So, Professor Nowak, Russia has violated a number of international laws in its war against Ukraine. Could you maybe elaborate on the types of crimes, as war crimes, crimes against humanity, and the crime of aggression? And could you explain to us why we need a special tribunal in order to get to the most high-ranking people responsible for these crimes?
Yes, as Wolfgang Benedek has said, there are numerous crimes against humanity and war crimes committed and also documented. There are many international and also Ukrainian investigations going on, including the International Criminal Court. The problem is to find the perpetrators. You can find the perpetrators on the ground who were committing the crimes in Bucha, for instance. But it's very difficult to prove the chain of command that these crimes have been directly ordered by the highest military and political leadership in Moscow. The crime of aggression is totally different. And I just read you, it's short, out of Article 8 bis of the Rome Statute, the definition of the crime of aggression. It means planning, preparation, initiation or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state of an act of aggression which, by its character, gravity and scale, constitutes a manifest violation of the Charter of the United Nations. Violation of the Charter is Article 2.4, the prohibition of the use of force. For the first time in history, this was laid down in the founding treaty of the United Nations. It's the worst crime because all the other crimes are a consequence of the crime of aggression. So it is defined, but the ICC is not competent in this case because neither Russia nor the Ukraine have ratified the Rome Statute. The Ukraine has accepted crimes against humanity and war crimes, but the crime of aggression needs, if it should be prosecuted, a special tribunal. That is very important, and if you go back in the history, all the special tribunals that we had did not include the crime of aggression, with the exception of Nuremberg and Tokyo. So we are looking now into what are possibilities. Of course, all those ad hoc tribunals for the former Yugoslavia, for Rwanda, cannot be used because they were established by the Security Council of the United Nations, which of course cannot take a decision in this case. The special court in Sierra Leone was also initiated by the Security Council, but perhaps there are similarities that might be used. In my opinion, the extraordinary chambers in the courts of Cambodia that were based on an agreement between the United Nations and the government of Cambodia, and the agreement of the United Nations was received by a resolution of the General Assembly of the United Nations. So it didn't need the Security Council. And I think that is important. There are certain both politicians and also academics that say the Uniting for Peace resolution that goes back to the Korea War, saying that if the Security Council as such is incompetent because of the veto power of the 5 permanent members, then there is a certain responsibility of the United Nations General Assembly acting by a 2/3 majority would also be possible. And we have seen that already when 141 states actually condemned the war of aggression, and they used this term explicitly of the Russian Federation, and only a very, very small number of the closest allies of the Russian Federation actually voted against. So that is where we are standing. There are many different ideas, but I think it is extremely important because there we don't need what Wolfgang Benedek said. We don't need big investigation commissions. It's all public evidence. President Putin himself said everything very, very clearly. So we have all the evidence that the crime of aggression has been committed. And that's why it is so important that we find a way that an international tribunal, it should not just be a domestic tribunal, shall be established in order to, at the end of the day, hold the main political and military leaders, and that is in particular, of course, President Putin, also Minister of Foreign Affairs Lavrov and others, to actually be brought wherever it will be, in The Hague, hopefully it's the capital of justice in the world, or in any other place, but it needs to have the international support. Thank you.
And Dr. Reisinger, you can tell us a lot about that special tribunal because you're actually involved in the preparations of it. Can you please elaborate?
Thank you very much. Let me also express my profound honor to participate in today's expression of solidarity and quest for justice for the war in Ukraine and the crimes being committed there. Professor Nowak has already explained and has gone into some of the features and special legal questions that regard the crime of aggression. Let me continue where you stopped with the definition of the crime of aggression in Article 8 bis of the Rome Statute. So we have this generic definition, but it's followed by a list of acts that are examples and are in any case to be considered as acts of aggression. So we have this list in Article 8 bis of the Rome Statute for the International Criminal Court. It's the same list that we find in General Assembly Resolution 3314. And interestingly, in our particular context, it's the same list that we also find in the draft definition of the aggressor that was introduced at the League of Nations in 1933 by the Russian delegation. So much for the continuity of what we understand as an act of aggression. On this sad anniversary, we have seen evidence that each single act of aggression that is listed in this documents has been committed. Some of them have been committed in 2014 with the annexation of Crimea, with the increase of Russian troops in violation of the Black Sea Agreement, and allegedly also with regards to the sending of armed groups into eastern Ukraine. Professor Benedek has mentioned the MH17 incident, and we have seen a trial very recently in the Netherlands on the question of accountability for the downing of this airplane. And the court has found that the Russian Federation had overall control over the groups that were active in eastern Ukraine. Now, that might not yet be enough to establish state responsibility for sending those groups, but a few weeks ago, we have seen a preliminary decision, a jurisdictional decision of the European Court of Human Rights, where the court found effective control of the Russian Federation over those territories and persons in it. So that might be another lead for an act of aggression already in 2014. But of course, 1 year ago, we had a massive escalation and a massive enlargement of the battlefield from eastern Ukraine to the total territory of Ukraine, a massive increase of active Russian troops being on the ground in Ukraine, and also an increase of actors, of state actors that are involved in this conflict. Because if we go back to the list of acts of aggression, Belarus, by allowing its territory to be used by the Russian Federation to commit an act of aggression, did not only participate in a Russian act of aggression, but committed an act of aggression itself. Now, we do have a permanent institution that deals with crimes under international law, the most serious crimes, the International Criminal Court. And the ICC has jurisdiction over the crime of aggression. It also has jurisdiction over the situation in Ukraine. And it is rather difficult to explain to a non-lawyer why, in this very specific situation, the ICC cannot exercise this jurisdiction. Now, of course, we can go back to Kampala, and it also becomes understandable. It was a political compromise, and those that wanted a definition of the crime of aggression finally to be included in an international treaty made huge concessions. A majority of states did not want the jurisdictional regime that we have at the moment. It was a political compromise. And if we are thinking now, if we are being confronted with this gap in enforcement of the crime of aggression, there are two options. And my opinion is that we need to pursue them in parallel. One is to have a rather quick solution for a tribunal that is competent for the situation in Ukraine with regard to the crime of aggression. That would be the establishment of a special tribunal, because we need to fill this gap. The second avenue, and this is as important, in particular for the international rule of law, is that we change the jurisdictional regime of the International Criminal Court so that we do not face another situation where the ICC has jurisdiction over the crime and over the situation but cannot exercise it. Maybe I should stop here?
I'm afraid so. Very little time. But let's stay at the topic, the special tribunal. What is actually needed? Maybe you could answer, Professor Nowak. What's actually needed? How much international support is there for such a special tribunal?
I mean, there's a lot of international support. Of course, the European Union is at the forefront. We had the European Parliament already a long time ago asking for that, the Parliamentary Assembly of the Council of Europe, the Committee of Ministers of the Council of Europe, etc. I could go on. Of already this famous resolution of the General Assembly speaking about aggression already paved the way for that. I mean, what we need now, and there are all kinds of countries. I would like to mention also Liechtenstein. It's a very small country, but it's very, very active going on together with Lithuania and others, really paving the way, finding the possibilities, really looking what are the different possibilities, and getting, of course, what you need is at least a majority in the General Assembly of the United Nations. There is a group of friends, there's a group, and as I said, the EU is very strongly in favor and is together with other like-minded countries putting together a group of states on which you can rely. And then it's a question, what actually shall be demanded, and if the demands are too high, there might be other states that would not go along. Of course, it would be ideal if you have a similar majority like 141, as 2/3 majority would be the best that we can achieve, but that needs a lot of diplomatic efforts in New York to really get that. But I am very confident that at least a simple majority, which would be needed in any case if you want, because then the General Assembly can adopt a resolution requesting the Secretary General to draft an agreement with the Ukraine. For that, you only need a simple majority, and I think that should definitely be possible.
I hope you agree, because I've got another question from a practical perspective. Would the accused have to be present at the trial, or could they be trialed in absence?
Well, it depends. So we are at the very start of the negotiations. There was huge momentum that has built up within the EU at the end of last year, at the beginning of this year. Now it's time to go out and reach out to other regions of the world and see what could be acceptable to them. Trial in absentia are not unknown. Ukraine can conduct trials in absentia. The MH17 trial was a trial in absentia. I'm a bit more skeptical also with the experience of the Special Tribunal for Lebanon, whether this is a feasible option. But even if we do not have trials in absentia, if we have a tribunal that is based on international law, that would not need to accept personal immunities. And personally, I think if we want to fill a gap with a special institution, with a new institution, we should not create one that would then not be able to prosecute all perpetrators or need to wait until certain persons are out of office. So if we have this, the tribunal could go as far as investigating, preparing the cases, securing the evidence, and depending on how the statute will be written, either issue an indictment and or issuing an arrest warrant. And this is a step that a national court or a hybrid court based on national law would not be able to do. If you think of Eurodia, the circulation of an arrest warrant is a violation of international law, not for an international tribunal. And having an arrest warrant, even if we cannot immediately secure the accused, is a huge step in accountability, in having a document that was reviewed not only by a prosecutor but also by judges, and that establishes on the basis of criminal law standard that there are strong reasons to believe that certain persons have committed certain crimes. And this would be a document that would be public, that would be out there, that could lead to the apprehension of certain individuals, and also have a huge impact on dealing with the aftermath of the war on a national level.
I'm afraid we have very little time remaining, so I want to talk a little bit about solidarity as well, as it's not only about justice, it's also about solidarity with Ukraine. Professor Benedek, you just wrote a piece in a newspaper today about how it's the recent calls for negotiations, whatever their intention may be, are dangerous, and also obviously for the solidarity, but also from a perspective of law. Can you elaborate on that? Why?
Thank you very much for this opportunity. Indeed, I have some concern about the decrease in solidarity with Ukraine by calls for negotiations, which give the impression that by limiting or reducing the military support to Ukraine, defending herself against the Russian aggression, the bloodshed could be terminated, even if this meant to enable Russia to achieve parts of its war aims. These calls, which apply to old anti-NATO and anti-war sentiments, do not sufficiently take into account who is the aggressor and what this could mean for the future of the basic principles of international law, like the ones in the Charter of Helsinki and the UN Charter, that state sovereignty and territorial integrity must be respected and borders must not change by force. If allowed to set a precedent, this could have extremely negative geopolitical consequences. The total denial by Putin of the facts, by creating alternative truths, is a threat to the cohesion of our societies and also threatens European solidarity. I see that there is an emerging unholy alliance of Russian-friendly political forces, parts of the peace movement, people who are afraid of the economic consequences or the escalation of the conflict, even the use of atomic weapons. And this all is actively pushed by Russian propaganda, using troll factories to distribute disinformation, in particular in the social media. So looking at the situation in Russia, where hundreds of thousands of mainly young people are leaving the country because of the repression, because of the war, because of a lack of a future perspective, this explains why Ukrainians by no means want to live under such a regime. With their resistance, they also defend our European values like freedom, democracy, and human rights. But it will be important to engage into debate with these citizens, these concerned citizens, in order not to duplicate what happened in the COVID crisis, where we did not discuss with the deniers, and they then moved to right-wing political parties and really become a political problem in our societies. Nobody can be against negotiations to end the war. But the basic principles of our present world order, as confirmed by the United Nations General Assembly only yesterday, must not be sacrificed. Without a restoration of those principles and without justice, there can be no just and sustainable peace. Any compromises can only be decided by the people concerned, and this is the Ukrainian people. Thank you.
Thank you. Now, minutes remaining, so one last round. Would you like to reply to that? If not, I would like to know if you can tell us, how long do you think it could take until we can actually have a prosecution? Is that answerable even?
I think I want to join what Professor Benedek said. It's the principal country that is concerned is Ukraine, and certainly they will be in charge of concessions, if any. With regard to your question, evidence is there. It has been mentioned. It's easily accessible because we rely on public statements, we rely on the Constitution, who is in charge for certain decisions. So it depends on the political will to have the body that can look into this evidence. And this is the creation of a special tribunal. Thank you.
I think it can go very quickly. If the political will is there, if the General Assembly is adopting a resolution asking the Secretary General to negotiate an agreement with the government of the government of the Ukraine, of course, would be very much interested to do that, and then you have to define what is the law applicable. It has to be based on, both on Ukrainian law, which includes the crime of aggression in the Ukrainian Criminal Code, but in particular also international law. If that is all decided, the tribunal as such can be established very, very quickly. And as I said, the evidence is there so that also you can proceed in charging certain individuals and issuing an arrest warrant. I think that's what we can do in a moment, and then we have to see further.
I think we have another minute. So, I mean, literally, we want to get Putin in front of a court. So we need an arrest warrant. How can we imagine that actually happening? So there's international arrest warrants, and if people are Putin and other people, high-ranking Russian politicians and people from the military, if they're unclever enough to leave the country, then they could be trialed, they could be caught. And is that how it works? A very basic question.
I mean, just let me go back for a moment to the former Yugoslavia. And I was very much involved there. And I know when, for the first time, President Milosevic has been charged, Mr. Karadzic, Mr. Mladic, everybody said at that time, already in the 90s, they will never be brought to justice. We will never have an... finally, every one of those three most important criminals actually ended up in The Hague. It might take some time, and it took quite a long time. And I'm also not saying that President Putin will be arrested in the next year. That is totally, impossible. But there might be a time after President Putin. The very fact that there was an arrest warrant, which means that these people cannot travel anymore, at least to most countries. I mean, we had the same also with indictments by the International Criminal Court, already is a very, very strong signal. They became lame ducks. They can no longer actually appear on the international scene, etc. So I think it's a process. We should also not be too impatient, but I think it's important that the decisions are taken.
Yes. Professor Benedek.
Just allow me one remark. We have been focusing on this special tribunal, and rightfully so, but I would also like to emphasize how important it is to support the Ukrainian general prosecutor in dealing with this large workload of cases. Some countries have made prosecutors available, secondments, and so on. European Union has done a lot with Eurojust, the genocide network, etc. There is the principle of universality, which allows every state to prosecute who has it in the law, and this is quite a number of states. So there are a number of possibilities to deal with, let's say, ordinary war crimes, and I think this is also important so that justice can be seen to be done quickly. Thank you.
Dr. Reisinger?
Just to add and share this conviction, we have an international criminal justice system. And since we have the permanent International Criminal Court, we see it as the center. But it works on the principle of complementarity, and the main responsibility to prosecute lies with states. So not one entity can do it all alone. It can only be all those entities on the international and on the national level working together to provide as much justice as possible for a given situation.
I think we have 3 more minutes, so I would like to ask you, sorry, this is very spontaneous, it's getting more, yeah. So I would like to ask you, is it, who's going to prosecute, who could be the possible chief prosecutors? There already a name or a, no?
No.
No. And what role
it's too early.
Too early, okay. What role could the ICC actually play in the, would they play a role in the special tribunal as well?
Well, the ICC is already investigating, and there was a preliminary examination opened in 2014, and they're looking into war crimes, crimes against humanity, and I'm not aware yet whether they're also looking into the crime of genocide. So they're collecting evidence, and I would not be surprised if we see either arrest warrants or a confirmation that sealed arrest warrants have been issued by the ICC. The ICC cannot go into the crime of aggression. That's why we need a specific, a special institution, but there should, of course, be a very tight cooperation between those institutions. Okay. And that's why it's also proposed that a special tribunal might have its seat in The Hague, so that the practical cooperation, when it comes to sharing of evidence, when it comes to, that's not a very correct expression, but the sharing of accused. So if we have an accused in custody and the person might be facing a trial before both tribunals, there's the question, could this be in parallel? Would it be one after the other? So these are issues of cooperation that need to be dealt with, and where we also probably need to have an agreement with these two courts. Otherwise, I do not think that a special tribunal would in any way take resources from the ICC or interfere with the traditional mandate of the ICC, because all proposals that are on the table for a special tribunal only concentrate on the one crime, the crime of aggression.
Mm-hmm. Maybe two very quick replies. And then
I just wanted to point out one issue which we have not yet touched upon, but which was the topic of a recent conference I attended, and this is assistance to the victims of war crimes and crimes against humanity. You can see from the number of cases that there are so many victims, and they need, on the one side, material support, they need psychological support. This is an enormous field where every state, every institution can play a role, and it is needed urgently. Thank you.
Last word on that?
Yeah, I think there's not much anymore to be added, but there are all ways of cooperation between international criminal tribunals. For instance, to give you an example, when Charles Taylor, the former president of Liberia, was charged before the special court in Sierra Leone, for security reasons, they said it's better to do it in The Hague, in the premises of the International Criminal Court. So also this special international tribunal, should it be established for the crime of aggression, might also very, very closely cooperate. There are even some people saying, why not asking the chief prosecutor of the ICC to become also prosecutor? In principle, it's possible. Whether it's very wise, it's a different question. So there are all ways and means of cooperating and also reducing the costs.
Good. Thanks for that overview. I think we really have to stop here. It could go on for hours. It's a very interesting topic, very complicated, very complex, very important. Thanks a lot for coming. I'm honored to be here today, and I'm going to hand back over to